All right, here we are in the final video. This is a summary of everything we've talked about today regarding how to initiate your case if you're looking to petition to modify and or enforce your underlying decree or custody order. So for case initiation, you're going to draft and file the following documents: your cover sheet, your confidential sensitive data form, your order to appear plus a petition for order to appear if that's required in your case, a petition to modify and or enforce, a proposed parenting plan if you're requesting to modify parenting time, a current child support worksheet along with the child support worksheet showing what you want child support to be changed to if you're requesting to modify child support, and then a statement of sums due if you're requesting to enforce spousal maintenance and or child support. Okay, service of process. So you filed, the court issued your order to appear. Now you need to serve the papers. You can do that through an acceptance of service and then e-file the signed acceptance of service to show service is completed. You can utilize certified restricted mail and then e-file the affidavit of service by certified mail and attach a copy of the signed green card to show proof of service. You can hire a process server and then e-file the affidavit of service to show proof of service. If your ex-spouse or co-parent is avoiding service or you can't find him or her, you can utilize the motion for alternative service or publication. And then keep in mind, once you've completed service, if modification of spousal maintenance and or child support is on the table, then you've got to complete an affidavit of financial information and file it and exchange it with the other side within 20 days of service. Regarding responding to the petition, it's optional in this post-decree, post-order context. However, if you are going to file a response, it's due at least 3 business days prior to the hearing. And if you're going to file a response, then you'll need to file your cover sheet and sensitive data form, your response, and then an affidavit of financial information if child support, spousal maintenance, or legal fees and costs are at issue. Once you've responded, the next steps will be, the response is optional, but the next steps after the issuance of the order to appear, if the court sets a resolution management conference, then 5 business days prior to the RMC, you're going to mail your Rule 49 disclosure statement to your opposing party, e-file your proposed resolution statement, and complete a meet and confer call with the opposing party or their lawyer to seek to resolve as many issues as possible. And then if an evidentiary hearing is set, you want to calendar that date and all the deadlines as soon as possible. Disclose all your witnesses and documents that you want to use that you haven't already disclosed. Draft and file your list of witnesses and exhibits. Submit your exhibits to the court by the deadline. Draft your hearing outline. And then if the court orders, you may also need to do a pretrial statement. And we have separate videos on how to do a pretrial statement. So those are the next steps after the issuance of the order to appear. All right. Thank you so much for joining me today. Bring all of your questions to the Q&A. Thanks so much.